Ladies and gentlemen, hello. My name is Paul Cheng, and I wanted to thank you for coming to my channel. I wanted to thank you for joining me. Today, we're going to be talking about and going through more of the information regarding hire to fire, both from the employer side and the employee side, so you know your rights and obligations in California. There are now we've talked about the independent contractor, let's talk about employees. There are two types of employees. One are exempt employees, and the second type are non-exempt employees. What's an exempt employee? An exempt employee in the state of California, you don't have to give them overtime, you don't have to give them meal breaks, you don't have to give them rest breaks. But the exemption actually requires two things. One is 2 times minimum wage. 2 times minimum wage. And the second one is job duties. And that's a big problem actually, because there are a lot of employers that fill one but don't fill the other requirement for an exempt employee. So let me give you an example. Let's say that you hire a person, you pay them a lot of money. You pay them $10,000 a month to take out your trash or to be the front desk worker. Can they be able to be subject to no overtime, no meal breaks, and no rest breaks? The answer is no. Even though you paid 2 times minimum wage, they do not fill the job duties of exemption. There are 3 types of main exemptions in California. There are other types, we've got a lot to go through today. First type is professional. The second type is managerial, and the third type is administrative. So I'm going to go over that again. First type is professional. What is a professional? They typically have a license. Attorneys, doctors, accountants. California, nurses, they are non-exempt. Very difficult to make nurses exempt. So if you're in the medical field and you hire a nurse, be careful. The second type are going to be managerial. Managerial, again, 2 times minimum wage. Managerial, they have a requirement. They have to manage at least 2 people or more. So if you're a department head, I've actually had lawsuits like this. The employer will come to me and they say, this person's exempt. We pay them 2 times minimum wage. I say, great. They are exempt. They are a manager. I say, great. I say, how many people do they manage? They say, nobody. They're the department head. They're the only person in the department. The problem is this: a manager must manage 2 people or more. If they do not manage 2 people or more, they are not a manager. They are not a supervisor. They are not subject to exemption. The third one, people litigate the most, and that is administrative. People that are administrative, they're not licensed, they're not managing people, but they actually have over 50% of the time when they have independent duties that they can be able to work on. That's a huge problem, because if you are administrative, you could be the bookkeeper. You may be the CEO's administrative assistant. Some people actually argue that the front desk could also be administrative as well. So this area of law, heavily litigated, very difficult to prove either way, but again, California law says if for any reason you are equal, they are going to be a non-exempt employee. What do you get as a non-exempt employee? Now I've used that word exempt, non-exempt. A non-exempt employee is going to get overtime. Minimum wage, overtime, meal breaks and rest breaks. They obviously need to get workers' compensation, but let's talk about overtime. Overtime in California are 2 big types. One is daily overtime. The second is weekly overtime. Weekly overtime above 40 hours need to be paid. Daily overtime, weekly overtime, whichever is more, you pay that amount. So I'll give you an example. Let's say you have an employee who works 10 hours a day. 8-hour workday, but they work 10 hours a day. How much overtime is that? 2 hours. However, if they work 6 days at 10 hours, do you know what their overtime is? It's not 12 hours, it's 20 hours. Why? Because on the 6th day, 10 hours a day, they've worked 60 hours. 60 minus 40 hours is 20, even though every day, daily overtime is 2. So they get 20 hours of overtime, not 12 hours of overtime. And why is that important? Because there are a lot of companies that actually pick one. They say, oh, we'll just do daily overtime, but they don't calculate the weekly overtime. And what ends up happening? They get sued and they lose. Meal breaks in California. For every 5 hours a day, you need to give a 30-minute meal break. For every 5 hours a day, it is a 30-minute meal break. So on an 8-hour workday, you need to give a 30-minute meal break. The 30-minute meal break needs to be documented. Why? Because in California it says that if the employer does not have accurate documentation, employee can make a reasonable approximation and they win the lawsuit. That's it. Reasonable approximation can mean many different things. I actually had a lawsuit where there was a security guy that he basically worked in the wholesale diamond district and he lived in a trailer. You know what he claimed? He claimed 24 hours a day he was working because when he was sleeping, he was protecting the employer. Was there a time card? No time card. Made the situation very difficult. Although I think his reasonable approximation was untrue, but the reality of the law is it gives the employee a lot of leeway to be able to make claims that many times may seem unreasonable to the employer, but from a lawsuit perspective, it could actually be a very viable claim if the employee is actually sleeping there. But in terms of going back over to the meal break issue, is in terms of meal breaks, every 5 hours you need to give a 30-minute uninterrupted meal break. Uninterrupted meal break. If you don't give them a full 30 minutes, you have to pay an extra hour. Some employers say, well, what about if they just eat at the table? Is that okay? That's okay, but you need to pay an extra hour because if the employee is called back to work during the 30-minute meal break, then it's an extra hour. Some employers say, well, what about if I pay the penalty? If you pay the penalty, you need to put it on the time card. It needs to be separated out. If you don't separate it out, no attorney is going to be able to understand that you've paid that penalty. Now, there is California law that says if the employee does not work over 6 hours a day, they do not need to get a meal break, but that needs to be documented. So what I've been recommending restaurants is for them to do a 2-shift 6-hour. So the restaurant is actually open 12 hours, and then you basically do a 6-hour shift and a 6-hour shift. And in terms of those 2 6-hour shifts, you do not have a meal break. The employee can just eat really quick, but you have them document that they don't want a meal break because the law is eating isn't a meal break. Just the fact that you eat is not a meal break. And so I want you to know that you can have that issue where you have 6 hours, totally legal, employee works up to 6 hours, no meal break is required. That actually begs the question, what about a split shift? What is a split shift? A split shift, restaurant people consider split shifts just to be 2 shifts. But actually, among attorneys, split shifts could actually have very serious meaning. A split shift is where you have an employee work 2 separate shifts, and that employee has a break of over 1 hour. So let me give you an example. A lot of Japanese restaurants, they close between 2 to 4. They do that so their employees can be able to have a meal break. You close the restaurant and you don't do anything. The employee works, let's say, from 10 to 2. And then they come back and they work from 4 to 8. Is there any overtime? No overtime. But you have to pay a split shift premium of 1 extra hour. So if an employee has 2 shifts in 1 day and the break in between is more than 1 hour, you are required to pay a split shift premium of an extra hour. even though the employee may not have worked overtime. So let's talk about rest breaks. In terms of meal breaks, we talk about it being documented. Rest breaks are not required to be documented. You just need to provide them. And in fact, case law have said that the employer doesn't have to police the employees to take a rest break as long as it's provided. So the rest break, employee can go out and smoke, employee can go out, run around the block, think about it a little bit. So really, every 3.5 hours, you give a 10-minute rest break. That's a legal requirement. You just need to give the opportunity. If the employee doesn't take that rest break, it's not required to be documented. So just to let you know, it's not a required documentation. However, we talked about best practices. In my opinion, it's great if you can fit it on the time card where the employee can be able to provide the rest breaks. It's very rare that an employee will sue a small company for just rest breaks. However, there are lawsuits where employees have sued big employers for just rest break violations. And that really falls under what's called PAGA and class action. I've dealt with both of them, both are monsters. But at the same time, PAGA, in my opinion, has been hitting small businesses even more. Really want to warn people about PAGA. Just because there's a violation of law with one employee, it can bleed over into a 1-year period. I would say 1 to a 1 year plus period, depending on if the employee is still working, where they basically cover all the employees with all types of violations, and they're able to recover that. Yes, a large portion of it goes to the state of California, but yes, it's still a violation nonetheless. Just to let you know, there is some risk. If you intentionally misclassify your employees as independent contractors, it can be a misdemeanor. There are a lot of business owners that are green card holders that may not even have status in the US. So just to let you know, very interesting that many people that are undocumented, they're able to open up companies. So undocumented people can still open up companies and use that EIN number. The EIN number is the tax number that's actually given to you. But what ends up happening is they still get in trouble with immigration because there's a lawsuit and it's shown that there's intentional misclassification, where the labor commissioner comes, realizes there's intentional misclassification, and therefore you end up having immigration trouble. Don't mean to get too political, but just to let you know, in California right now, labor and immigration totally tied in together. In 2025, really want to warn you that the intentional part is really being pushed by a lot of people. A lot of people say, well, I didn't have the intention, I didn't know the law. But actually, if you've been paying your employees illegally over a number of years, that can fall under the intentional classification, then making it a situation where you have immigration trouble, which we're really trying to avoid. Thanks for joining me. We've been talking about a lot of issues related to employer, employee, and labor law. Next time, we're going to go further on those issues to be able to discuss more detailed information and what I call hire to fire. Thank you.